Good afternoon. My name is Beata Leah. I'm an immigration attorney at Minsky, McCormick, and Halligan in Chicago, an immigration law firm. That's all we do. And I wanted to take this time today to talk specifically to individuals who are on DACA, because I know all of you are nervous right now in anticipation of a Supreme Court decision that's expected really any week now, as early as maybe next week. And so, in that decision, we don't know whether or not the Supreme Court will cancel DACA or not. And I know you're all nervous and you have a lot of anxiety. And so I want to talk to you specifically about 3 questions that I want you to get answers to. I want you to ask yourself these questions, and then I want you to investigate and ask your family to get answers to these questions. These are very important questions. Whenever I have a consultation with someone who's on DACA, these are the first 3 questions that I ask. I want to know if you have a yes to one of these 3 questions. And if there is a yes to these 3 questions, there may be more options for you to legalize your status, to become a permanent resident of the United States, and not to rely on DACA, because DACA, of course, is wonderful, but it's not permanent. And so I know there's a lot of anxiety, especially under the Trump administration and the expected Supreme Court decision. So again, we're going to try and get you to get 3 answers to these 3 questions. And then if you have a yes to one of these 3 questions, then I know that there may be more options for you. Okay, so the first question is, are you eligible for 245I? And many of you may already know what 245I is, but surprisingly, I still have consultations regularly with DACA beneficiaries who do not know what 245I is and do not know whether they have it or they don't have it. And so 245I is an old law that allows individuals who've been in the United States unlawfully, either they entered unlawfully or they overstayed their status, to apply for permanent residency from within the United States without departing, without having to go to the consulate, without having to worry about waivers. And to qualify for 245I, someone must have sponsored either you, your parents, or your spouse by April 30th, 2001. And that could have been a family member would have filed a petition, an I-130, a green card sponsorship application for, again, you, your parents, or your spouse by that date. It could have been an employer. And so you want to find out, again, has anyone sponsored one of your parents, for example, if you're younger and you're not yet married? And if you are married, has somebody sponsored your spouse, for example? Again, considering the age group of most DACA beneficiaries, it's unlikely that anyone would have sponsored you directly by April 30th, 2001, but it is possible that someone may have sponsored, again, your parents or your spouse. And so if that's the case, in some instances, that makes you eligible for 245I by nature of that relationship that you have. So again, ask your parents, ask your spouse, and find out if anyone sponsored you, your spouse, or your parents for an immigrant petition, whether it be a family member or an employer, by April 30th, 2001. And if so, you may have 245I, and that opens the door for you for a variety of green card options. Now, the second question that I want you to get an answer to is, if you don't have 245I, you've done the research, you've asked your family members, you asked your spouse, and no one's ever been sponsored by anybody. No employer, no other family member has sponsored them. Okay, fine. The second question is, have you accrued less than 6 months of unlawful presence since you turned 18? So our immigration laws are set up in a way where it punishes you for being in the United States without lawful status only after you turn 18, when you become an adult. So if you obtained DACA either before you turned 18 and you've had it continuously since then, or if you obtained it really before you turned 18 and a half, because again, the punishment would start only if you've had more than 6 months of unlawful presence after your 18th birthday. So if you obtained your DACA really by the time that you were 18 and a half and you haven't had any long gaps between your DACA approvals or any gaps between your DACA approvals, then it may be that you don't have 6 months or more of unlawful presence after your 18th birthday. And in that case, you may need to consular process a green card application, whether it be through a family member or through an employer, but you could do it without needing a waiver because you don't have the amount of unlawful presence that requires a waiver. And again, so the question that you want to find out is, when did I get my first DACA? And have I continuously extended it since then? And what gaps existed between those DACA approvals? And when you look at the periods of time between when you turned 18 and the time that you got your DACA approval, and any gaps in between, if there were any gaps between extensions, if that period of time is less than 6 months, then you may have you may not need a waiver. You may not have a bar on returning to the United States if you have to consular process your case. Okay, so again, the question is, do you have less than 6 months of unlawful presence since you turned 18 by looking at your DACA approvals? Okay. And then the third question I want you to get an answer to is, again, if you don't have 245I and you don't have unlawful presence, you do have more than 6 months of unlawful presence, I guess I should say, then do you have a qualifying relative that would allow you to consular process your case with a waiver? So for a waiver, you can only use certain family members to waive your unlawful presence in the United States. Unfortunately, children do not count. So you're looking to see, are one of my parents lawful permanent residents or U.S. citizens already? Or is my spouse a permanent resident or a U.S. citizen? If you have a qualifying relative who is a U.S. citizen or permanent resident spouse or parent, then you can use one of those relatives or both, if you have more than one, to waive your unlawful presence and potentially consular process your case. So again, the three questions are, am I eligible for 245I because someone sponsored me, my spouse, or my parents by April 30th, 2001? Or do I have less than 6 months of unlawful presence in the United States because I obtained DACA shortly after my 18th birthday or right before my 18th birthday, and there are no gaps or short gaps in between, so the total amount of time between my 18th birthday and any gaps would be less than 6 months? Or do I have the right qualifying relative for a waiver if I need one? And that would be, again, a permanent resident spouse or parent, or U.S. citizen spouse or parent. Now, what does that mean? If you have a yes to one of those three questions, what does that mean? Well, it means that you can potentially apply for permanent residency, not just through marriage, because that's what a lot of people think. Oh, I have to get married. I have DACA. Getting a green card through marriage is my only option. That's not true. There are other family members who may potentially be able to sponsor you, but also, most importantly, most of you are professionals. You have jobs. Many of you are working on the front lines of this COVID crisis in healthcare fields and other essential positions. You're critical right now. And maybe an employer would be interested in sponsoring you. And again, so having a yes to one of these questions opens up the door for a variety of green card options for you, not just through marriage, but through other family members and also through employment. So again, do yourself a favor, get answers to these questions. And if you have a yes, consult with an immigration attorney about whether or not you have other options for permanent residency in the United States. I hope you're staying safe. Thank you, and I hope this helped. Bye-bye.